case. We've got the issue of standing. We have did the dog alert at all, and then if he did alert potentially, did he alert as to the bags that contained these drugs? And so I will start with the standing inquiry, if that's all right with the court. Below, the government challenged the issue of standing in their opposition brief on the grounds of abandonment, and that was the reason that the government said that there was no standing. And so that's page 35 of the joint appendix. The government's brief says that the defendant is precluded from seeking to suppress the luggage and its contents because he disclaimed the bags stored in the exterior compartment, close quote.
Is that, I mean, that seems to be true, at least with respect to one of the bags, no?
Well, Your Honor, there is a little bit of a, as I read Judge Coggins's order, he seems to have found that both bags were searched prior to the disclaimer of ownership. In particular, if you look at page 624, which has his opinion, there he talks about, well, I don't need to resolve the Miranda issue. I know that you, Mr. Duran, you say that there was this interrogation, but he says that he lacks standing to challenge the search of the luggage found in the bus's exterior luggage compartment because he disclaimed any ownership in the property when asked by law enforcement to claim his bag. And so there, and then the timeline he gave in his factual recitation, he seems to say that both bags were searched prior to the disclaimer. I would also note that if you look at the factual basis that the government proffered for the plea, they seem to say that the search of the bags, both bags, preceded the discussion with Mr. Duran.
That doesn't seem to line up with the record evidence, though.
Well, Judge, I will admit that when I go and I look at the video, I see that the officer, sort of, we have the video, I think, at 7:37, and he's like, oh, this seems surprising to me. He's very excited that he finds the drugs in the second bag. But again, just as I read Judge Coggins's order, that's what he said. Again, I'm asking the court to vacate what he did, and so we can go back and we can fix all of that if we need to. But as I understand the facts coming up here, Judge Coggins found that the search preceded the interrogation.
I guess you were about to get to your point. Maybe I don't want to make the argument for you, but the government argued abandonment. Now they're arguing a different theory on appeal with respect to standing. Is that your point?
Yes, Your Honor, and I'm perfectly happy to have you make my argument for me. That would be great.
No, I don't get paid enough to do that.
Yes. Because the budget has finally been approved and I'm getting paid again, I am happy to make the argument. Yes. So here, even if we conclude that there was one search, then the interrogation, and then the second search, if that first search was bad, you still got an issue of fruit of the poisonous tree. Secondly, we also have a Miranda problem because if he was interrogated without his Miranda rights, I think that you are supposed to suppress the words that he uttered, and the words that he uttered are the disclaimer of ownership. And so while Miranda doesn't allow you to suppress physical evidence, Miranda does allow you to suppress the words that the client used, and without those words, the government has no basis to claim that he abandoned his interest. So again, I think that however this results, I think we got to send it back to Judge Coggins to do some more fact-finding and some more analysis for us.
Okay. You want to talk about this issue of lawful possession?
Yes, Your Honor. So as I note, that there is a well-settled body of property law that says that if you're in lawful possession, that's prima facie evidence that you are either an owner or a bailee. But again, the government, as they teed the issue up for the hearing, the issue was just about abandonment. And so I don't know that the original counsel who handled the hearing, I don't know that he was on fair notice that the government was challenging that part of it. But again, even if you sort of set that aside, the government proffered evidence that he was that he loaded the bags in Atlanta. He wasn't stealing them from somebody. He wasn't running there. And under lots of cases about property, being in possession is 9/10 of the law, and so that creates a presumption that you are at least a bailee, and if he is at least a bailee, even if he's not the owner, if he's at least a bailee, then he's got a property interest in the bags, because under the law of property, if a bailee fails to return the bailment to the bailor, he could be sued. And as we know from Jones, we now have both the CATS framework, but also this common law property interest framework that we can use, and because there is a common law claim that could be asserted, that gives him a Fourth Amendment reasonable expectation of privacy under the Jones view of the Fourth Amendment.
So you do agree that, well, assuming that, this sounds like you may be suggesting that the government forfeited this issue of possession by not raising it or not giving notice to the counsel below, but you concede that there's got to be some evidence in a typical case that the possession was lawful, not just naked possession is not enough?
Well, Judge, if you look at those cases that I cited, it's peaceable possession is what creates the presumption that it's there. And so again, if the video had showed him snatching the bag from somebody and running it, that would not be peaceable possession. But the video that the officers talked about showed him in peaceable possession of the item, and so that is what creates the prima facie evidence of at least a bailment.
And is that Anderson on bailment, or is there a case that supports that?
Judge, I have cited the cases. Admittedly, they are kind of old, right? So I think, and I don't, I remember the names off the top of my head. I can get them for you for the rebuttal. But those are the ones that, like 1923 out of the state of Washington. There was one from 18-something out of the state of Illinois.
Ooh, some of the greatest hits are coming out.
Judge, as we like to say, well-settled authority, right? It's been the law for more than a century, or maybe even two sometimes. But yes, that is the property interest. But again, Judge, because we've got these factual issues, what I'm asking is not for the court to necessarily say that the suppression should have been granted, although of course I'm happy if you do say it. But if we need to have more testimony on that, then we can go back.
Yeah.
But again, I just don't know that it was put on fair notice for trial counsel.
Okay. Before you've got about 5 minutes. I think maybe the better use of your time would be to talk about what you opened with, and that is this issue of subjective versus objective evidence of the dog alerting.
Yes, Your Honor, and so I certainly hope that we get there with respect to overcoming the standing issue. But as you know, there's not any binding precedent from this court that settles the question. We have several district court cases, including in particular the case from Judge Reidinger, which I think is very persuasive. That's the Wilson case there. And there, what he said is, look, if we let it be just a subjective standard, then there's no way that a court can ever review what the officer did. And the whole point of the Fourth Amendment is that there's supposed to be some barrier between the officer and people's expectation of privacy. And so what we need is some objective sort of manifestation. There, Judge Reidinger said it doesn't even give you reasonable suspicion if the dog doesn't do what he's supposed to do. And there in Wilson, the dog was trained to sit, but he did not. The agent said that he lowered his head, he changed his gait, there were changes in breathing. Judge Reidinger said that doesn't even give you reasonable suspicion to continue it. I'm not asking the court to go that far. What I am asking is the court to say, look, this dog has been trained, he's been sent to school, he's been validated in all these hundreds of tests that he has to do, that when there are drugs, he sits. Here, everybody agrees he did not sit. But
there was other signaling behavior at that full hearing that the parties had before the district judge, correct? And that was explained through the testimony of the officer and through the testimony of the officer with regard to the dog's certification and qualifications.
The officer said, there was this sort of changing in breathing, and so based on the officer's experience, he said, I think it was an alert.
Experience with that dog.
Right, but that experience was not validated through the hundreds of tests, et cetera, right? So we don't, and so that's the problem. And so when you look at the video, I don't know that I see the same things that the officers do. And my whole point is that there needs to be the same standard as if a magistrate judge were there on the scene. And when the magistrate judge sees what the dog did, knowing that the dog has been trained to sit when he finds drugs, and he sees that the dog did not sit, would the magistrate judge on the scene say, yes, I'm going to sign a warrant right now? Or is the magistrate judge going to say, well, maybe there's enough to investigate further, so let's maybe pull out the bags and let's have him test again, because it's just not clear. Particularly if you look at the beginning of the video, the dog is very distracted because of all the cars that are flying by. And again, I just don't think that a magistrate judge on the scene, having seen all the stuff in the video, knowing that the dog has been trained, that when this happens, you're supposed to sit. He didn't sit. I don't think that a magistrate judge should have approved the warrant. And if a magistrate judge wouldn't have done it, the officer on the scene should not have said that I'm going to search anyway.
Wasn't there evidence in the record that the dog, it's true, his principal alert mechanism was the sit, but there was also, and correct me if I'm wrong, evidence in the record that he had alerted in different ways and somewhat consistent with what he did in this case?
There was some testimony to that effect, Judge, but how do we know that, for in those other cases, the breathing pattern was 60 breaths a minute as opposed to 30 breaths a minute, right? So that's the problem, is that we really have to just...
Well, there was more than breathing, though. I think it was sort of the lowering of the haunches. Apparently, Chaos is a bit dainty, didn't want to sit in the mud. And he said as much. The trainer said, you're not going to sit for me. Isn't that right? So he kind of expected that was what was going to happen, consistent with what apparently had happened in the past in instances where he had credibly alerted.
Well, Judge, again, as I say, it's sort of heads I win, tails you lose, right? So you're not going to sit for me, therefore you're alerting. You are sitting for me, and you're alerting. And the Fourth Amendment, I think, demands more than that. That what we need are these objective signs that you can explain to a magistrate judge on the scene, and the magistrate judge would say, yes, I agree, he is alerting here. Again, my point is that there was reasonable suspicion, and so we can investigate further. I'm not asking you to go as far as Judge Ridinger did, but I don't think that a reasonably prudent person, in the face of a dog who's been exceptionally well trained to sit in the face of drugs, he did not sit. I don't think a reasonably prudent person would have rifled through all those people's bags at the bottom of the bus. And with that, Judge, I will turn over to the government and be happy to come back and answer any questions in a few moments.
Thank you very much.
Thank you, Your Honor.
Morning, Mr. Garner.
Good morning. May it please the court, Ben Garner on behalf of the United States. This court should affirm Mr. Garcia's convictions because the district court did not err in determining that Mr. Garcia failed to satisfy his burden in establishing Fourth Amendment standing. Second, that he abandoned any interest in the second suitcase that was searched. And third, that probable cause existed to search the luggage based upon the dog alert to narcotics. I will start where my opposing counsel left off, and that is on the merits, unless the court directs me otherwise or has any questions at this point. Mr. Garcia's argument that because Canine Chaos did not react with a formal alert by sitting, that his alerts did not provide probable cause as a matter of law to search the luggage is flatly inconsistent with Supreme Court precedent and the standard embraced by the Supreme Court in Florida versus Harris. There, the Supreme Court squarely rejected the approach of a, quote, strict evidentiary checklist to assess a dog detection reliability, and instead indicated that evidence of a dog's satisfactory in a certification or training program can itself provide sufficient reason to trust his alert. And that is
so that means that if the dog did well at the academy, it doesn't make any difference how they alert or not alert in the field. That's where you read that Supreme Court case, because that's what it sounds like what you just read. You're saying as long as he got a passing grade and did well in school, when you come out in the real world, whatever he does is fine. That's basically what you just said.
Well, Judge Gregory, that is one factor for the court to consider as articulated by the Supreme Court. Here, we have more than just the training and the certification of Canine Chaos. We also have the testimony of Officer Wright. The court also indicated that the credibility of the handler is also important for the district court's analysis. And so here we had evidence that the district court found that Canine Chaos's satisfactory performance during certification and having as well as the handler's credible testimony sufficient to establish Canine Chaos's reliability. So it wasn't just the certification and the education and training of Canine Chaos, it was also the testimony of Officer Wright that the court evaluated and was there to assess firsthand his credibility. The district court specifically based its findings of reliability on the fact that the records documenting Chaos's certification to detect narcotics, including marijuana, cocaine, heroin, and methamphetamine. The fact that he was certified by a nationally recognized association and organization.
That seems to go again to the training and the fact that he did well in the academy. Apparently had a perfect record, it sounds like. But the concern is, notwithstanding that, if the defendant is being told, or the record evidence is that this canine alerts when he sits, that's his alert signal, and he doesn't do it in this particular instance, how is a trial court supposed to gauge that? I mean, at that point, it's entirely in the hands of the handler, isn't it, as Mr. Anderson says?
I don't think so. I mean, the certification and the training is objective criteria that the court can rely upon to make its
Right, but part of that training is the dog alerts when he sits.
Well, Judge Gregory, or excuse me, Judge Diaz,
I'll take that. I don't have a defense.
the fact that sitting is canine or was Canine Chaos's final response or final alert very well may be the gold standard for Canine Chaos, but the Supreme Court and this court has recognized that in Fourth Amendment principles there is a commonsensical and elastic standard that is applied, and in this case it wasn't just the training, and while the sit may be the gold standard, I would submit that it's not the only standard that a district court can rely upon. Here we had the testimony of Officer Wright that notwithstanding the initial certification, there was ongoing certification that he conducted with Canine Chaos. He testified in front of the district court that although the sitting may be a final response or a final alert by Canine Chaos, that there were other alerts that he would give. And that was based upon the direct observation of Officer Wright through the initial training as well as the ongoing training. In this specific case, he cited the fact that Canine Chaos, that his walking speed slowed, his tail pattern changed, breathing pattern changed, and began walking with his mouth closed. And the district court wasn't left with just relying upon Officer Wright's testimony. The district court also had the benefit of the body camera, and the record reflects that throughout the suppression hearing, Officer Wright frequently directed the government counsel to replay the body camera, and so he could see and point out for the court specifically where Canine Chaos was alerting. And so,
But the dog walked by first, didn't alert at all, right? Didn't it pass by the cargo hold and didn't alert at all?
and Officer Wright provided context and testimony as to that point. The fact that this traffic stop took place on the side of a busy interstate, he testified that weather conditions can certainly have an impact in the dog's ability to conduct a final alert.
More reason to be unreliable.
Not when taken into context the experience and training of the officer. Magistrate judge every single day rely upon the training and experience of case agents when approving affidavits, and that is the same testimony that was proffered to the district court in this case, was the certifications, the experience of Officer Wright.
See, the problem, counsel, is this, that I understand what you're saying, but the problem is in terms of guarding the Fourth Amendment right in the Constitution is when an officer says, he or she says something, we can question them and credibility and that kind of thing. But you can't cross-examine a dog. The dog is reliable solely because he or she reacts consistently in a constant way. And in the record, you put in that the dog alerts by sitting down. He did not sit down, that's undisputed. Now you're trying to put elasticity in the situation by saying, yeah, but it doesn't have to be, there could be more. But we can't cross-examine the dog. Dogs, animals are normally trained, they don't learn, they train. And when you train someone, you say, listen, when I say sick, you bite. When you smell marijuana, you sit down. And when I say come here, you come here. That's how they're trained. They don't learn, they train. They're trained when they smell it, sit down. They did not. Now you're saying this court should say, well, you don't always have to sit down. And the breathing pattern was like, you know what I'm saying? It puts so much distance in terms of protecting the constitutional right that it makes it very difficult, because what you just argued could be argued by anyone. Anyone. The dog didn't feel well. There was a ham sandwich in the cargo, and we don't know what it is, because why would the dog not sit down? Can you answer that question?
I don't need to, because Officer Wright did. Officer Wright testified that his belief that...
his belief. You just did.
Correct. He's the one. I mean, he also testified, Judge Gregory, about the months on end that he spent bonding with K9 Chaos, and the importance of that in terms of the training and the experience, as well as
More
his
reason that the dog should respond consistently.
Well, Judge Gregory, this court has certainly recognized the fact that the testimony of the K9 handler is absolutely critical to...
I agree, because when they said he sat down, we don't question that.
Well, if the court agrees that the testimony and the credibility of the K9 handler is important, then it should credit, just as the district court did in this case, the testimony of Officer Wright, insofar as his explanations as to why a final alert hadn't taken place. As I indicated, a final alert may be the gold standard, but it's not the only standard. And the fact that the district court judge had the training, the documentation, the fact that the district court was in a position to evaluate the body camera, coupled with Officer Wright's testimony before the court, gave the court ample objective evidence to predicate its determination of reliability on. I would note that other courts have rejected the standard that Mr. Garcia is advocating for in this case, a bright line rule. There's the 11th Circuit case in United States versus Brady, where the 11th Circuit, the panel of the 11th Circuit affirmed the district court's determination, rejecting the testimony of the precise expert that testified, defense expert that testified in this trial, or excuse me, in this hearing, and instead crediting the testimony of the K9 handler. And I would note too that in that case, the K9 had not conducted a final alert. There was other observations and that the K9 officers testified about to support the reliability in that case.
How many indicia of signals by the K9 is sufficient? Is there a mechanical test, or do we have to just take it on gospel that when a trainer says that the dog has done A, B, C, and D, that's sufficient and we don't need to question that?
Judge Diaz, I'm certainly not advocating for any mechanical test, and I'm not aware of any court that has embraced one. I think it is up to the district court to assess the credibility of the handler and the testimony. This is not a scenario that Judge Gregory was referring to in terms of a handler coming in and just opining that I had a sixth sense that my K9 was alerting to the presence of narcotics. Instead, he had very specific behaviors and actions that K9 Chaos exhibited that he pointed to and relied upon in support of his determination. And so, Judge Diaz, to answer your question, there's not a specific number that the government would point to, but there does need to be some objective indicia to support the determination of the handler. And in this case, the district court was satisfied that there was, coupled with the credibility determination that the district court made in terms of crediting the testimony of Officer Wright and rejecting or at least discounting the testimony of the defense expert.
So with respect to the, this issue of the dog alerting when he's sitting, he's trained to do that, right? You can see that that's what the traditional alert is, at least.
He's trained for that to be the final
Alert.
Yes.
Okay. So what did he do? This wasn't a final alert? Is that what you're saying? The chaos in this case?
That's correct. That's correct, Your Honor. And as I indicated, Officer Wright testified that based upon his training, his experience with specifically canine chaos, that that was not the only behavior that chaos would exhibit when he detected the presence of narcotics. And there was also testimony, and what he's basing this off of is prior traffic stops, as well as training and experience in controlled settings. So this isn't just Officer Wright stating it and the district court left to accept the testimony as gospel. He's got specific instances that he is pointing to support his belief in his statement that there is other observations or other conduct that canine chaos may exhibit, which would lead the handler to believe that the presence of narcotics are present.
That he had exhibited in the past to
Correct.
support an alert.
Correct.
Those were all training exercises, or were they actual stops?
Officer Wright testified as to both, that there were controlled training exercises as well as other stops. And as I also indicated, this was not just one alert short of a final alert. Officer Wright pointed to numerous conduct that he observed from the canine, and it was supported by the body camera footage that was displayed at the suppression
Do
hearing.
you agree with the holding, the final result in the Wilson case, Judge Reidinger's opinion in that case? Do you think that that was wrong as a matter of law, or do you think that the facts were just different there?
Your Honor, in terms of the Wilson case, I will hedge my answer insofar as these analyses are so fact-bound in terms of a determination as to whether a dog has reliably alerted to the presence of narcotics. I think it really depends upon the objective evidence that is presented to the court. What the government is rejecting is any sort of bright-line rule, and it's the rule that Mr. Garcia is advocating for in this case, is that there be a bright-line rule that anything short of a final alert that the dog is trained and certified for would be insufficient for a district court to rely upon. I think that does not find any support in Supreme Court case law, particularly Florida v. Harris, where the court invalidated the tests embraced by the state of Florida. As I indicated as I began my argument, there the court rejected any bright-line rigid test, and instead that just like in other Fourth Amendment settings, that there's a elastic, commonsensical approach that district courts are to take.
Did you, I know you said you wanted to hedge, but I'm going to push back a little bit. Do you think that Wilson, the holding in Wilson, was a bright line rule that we should reject, or do you think
Yes.
Wilson is on its face different factually, that it doesn't apply in this case?
Judge Diaz, my reading of Wilson is that, and the other district court cases that were cited by Mr. Garcia, is that it embraces a bright line rule that the government objects to and would ask this court to reject.
All right, can I ask you a question? Well, you want to talk a little bit about standing and this issue of possession, because it sounds like this is a theory that was presented for the first time on appeal. Maybe it doesn't matter. Tell me why you think we don't even get to probable cause because the defendant lacks standing.
Sure, Judge Diaz. This court has made absolutely clear to litigants who wish to challenge either the search of either an item or an area, that the burden is on the defendant to establish Fourth Amendment standing, and that the burden is on them to do so, they must demonstrate a legitimate expectation of privacy. Here, the government below challenged Mr. Garcia's Fourth Amendment standing, And notwithstanding that, for the first time on appeal, Mr. Garcia is advancing this theory of a bailment interest in the suitcases that were located in the luggage compartment of the bus. Your Honor.
Well, I understood Mr. Anderson's argument to be that what the government was focusing on below was abandonment, not necessarily that there was unlawful possession from the get-go.
Well, the government certainly on page 34 of the joint appendix put the defendant on notice that it was distinguished, that it did not believe that Mr. Garcia had the requisite possessory interest or privacy interests, and it specifically cited Jones versus United States, where, and that's a case where the Supreme Court characterized the defendant's possessory interests as that of a bailee. And so in that, the government was clearly indicating to Mr. Garcia that it did not believe, based upon the context and the specific facts of this case, that it was apparent that he had the requisite possessory or privacy interest to pursue the Fourth Amendment challenge.
So a defendant in physical possession of property, like it's clear on this video that he was, Mr. Anderson's argument that possession is 9/10 of the law with respect to lawful possession, that's not correct?
No, it's not. And the Supreme Court, as well as this court, have made clear that possession alone is insufficient to establish Fourth Amendment standing. To the contrary, a individual must show not only possession of the item, but that there's a legitimate or lawful expectation of privacy. And the court has, the Supreme Court has distinguished over the years the requisite showing depending upon the status of ownership. The Supreme Court has said that that the burden is less on an individual that is a owner who is legitimately in possession of the place or item that is being searched. However, someone that is a bailee or a non-owner must demonstrate a lawful or legitimate possessory right. This court's case in United States versus Daniels establishes that fact. There, the defendant was clearly in the possession of a vehicle. However, he put no evidence in the record that he was in lawful or legitimate expectation or possession of the car. In that case, he was operating a rental vehicle that had been rented to his girlfriend. The fact that he put no evidence in the records supporting the fact of his lawful or legitimate possession, this court found that he did not have Fourth Amendment standing, and that's the same standard that the government asked below in contesting the requisite possessory interest, and asked this court now to hold or to affirm the district court's conclusion that he did not have or did not demonstrate the requisite possessory interest.
And he would have to give up a Fifth Amendment right to do that?
No, Your Honor. The Supreme Court has held that a defendant who testifies during the course of a suppression hearing, that the government is not permitted to use those statements against him towards the issue of guilt at trial. This court in United States versus Daniels specifically held that in faulting Mr. Daniels for not putting up any evidence, said that he clearly could have testified but elected not to. In addition to testimony from the defendant in United States versus Castellanos, the court pointed to other evidence that a defendant can introduce to demonstrate a possessory interest. There, the court said that the defendant's failure to present evidence that anyone granted him permission to use the property subject to the search or to act as the owner's agent meant he failed to demonstrate a requisite possessory interest to the property. And so the government is not asking this court to hold that a defendant has to testify. There's other ways that he or she can prove the requisite possessory interest. But what this court has said and made absolutely clear is that the burden is on the defendant to show not only possession, but also legitimate or lawful possession, and that was not done in this case.
Thank you very much.
Thank you, Your Honor.
Thank you. May it please the court. To be clear, I'm not advocating for a bright line rule that says that a dog has to sit before any search can take place. What I am saying is that there needs to be objective criteria for a court to evaluate it. And so if we had, for example, this change in breathing patterns plus some nervous behavior on the part of Mr. Duran, or for some information from a confidential informant that maybe there are drugs there, those objective facts, we could draw a constellation and then maybe say probable cause exists. But on this record, all that we have is that the dog is well trained to do one behavior. He did not do that behavior, and the government says that that is enough for a reasonably prudent person to go rifling through a whole bunch of other people's luggage. And I think that the Fourth Amendment is a gold standard. That's what our framers wanted, right? So if you want the silver standard, that is reasonable suspicion, where you can investigate a little bit more. And I agree that the government did have reasonable suspicion, right? So yes, the officer said, well, maybe this dog, maybe he's trying to sit, but I don't know if he's really doing it. And so fine, take some time and do more investigation. I am not trying to cut law enforcement off at the knees. But what I am saying is that if you're going to say that what we have here was enough to get a warrant, if a judge had been on the scene and seen everything that that officer saw, I don't think that a judge would have signed that warrant. Because we've got, well, he was breathing heavy, right? But for the training, we have sort of objective criteria to know when he passes training or not. And so in the other times where the dog has breathed heavily, right, how many breaths per minute was it? Because we need to be able to compare this behavior to other behavior. And basically the officer is just saying, Judge, you've got to take my word for it, that I thought he was breathing funny, and to me, because I can read minds and I can read a dog's mind, that was what was going on.
Can I ask you about the Parada case, the 10th Circuit case?
I guess right.
Do you disagree with the holding in that case? Do you think it's factually distinguishable? We should reject it. What's your view of that?
Judge, again, my position is that you don't have to have a final alert all the time, right? It's just a question of we need objective criteria. And so if you don't have...
Objective criteria beyond the dog's behavior is what you seem to be saying.
Well, I mean, so... the fact that we had a half alert here, right? I mean, maybe that's something. And that plus some, hey, I see this guy over here, he's acting nervous. Or, hey, I asked everybody to claim their luggage and nobody got this. Gee, that seems funny, right? Those things where we could take it to a judge and then we could talk about, as a matter of law, would a reasonably prudent person proceed on that basis, yes or no?
That actually did happen in this case, but the timing, the sequence was off.
And that's exactly the problem here, Judge, right? And so what I'm saying that they should have done is either pull the bags off and line them up on the road, let's have the dog walk and see if he does what he's supposed to do, or if you don't want to do that for whatever reason, go and talk to the folks and see if you get further evidence that might cause a reasonably prudent person to go and rifle through other people's luggage. But before somebody goes and pulls out my underwear from my suitcase, I hope that the officer has got some objectively verifiable information, because I've got a privacy interest in my luggage, even if I'm on a bus. And so again, my point is that I'm not saying that the officers couldn't proceed with the investigation. It's just that they didn't. They skipped a step and they went right to rifling through the luggage, and that is what I say is the problem here. That yes, there was reasonable suspicion, they can investigate further, but they did not have the right to go and open up everybody's luggage on this record. And then as for the standing issue, again, I think that we need to send this case back to to Judge Coggins to sort of reevaluate some of the law under the right standard. My point is that I just don't think that original counsel was on fair notice given the statement in the government's heading on standing, where it says the reason we say he doesn't have standing is because he disclaimed it. I just don't know that the trial counsel was on fair notice that was really going to be the contested issue, that even if he hadn't disclaimed it, there is no standing, because that's the government's position here. I don't know if the trial counsel was on fair notice about that. And as I say here, of course, you've also got plain error because we were going to admit this evidence at trial. But again, I think we could resolve the bailment issue by just sending it back to Judge Coggins to ask him to sort of open up the record, and if you find there was a bailment, there is standing. If you find there is no bailment, then there is no standing, and that would be how I would propose to resolve that issue. If the court has no further questions?
Thank you very much, Mr. Anderson.
All right. I thank you, Your Honor.
I want to thank both counsel for their fine arguments in this case. Mr. Anderson, as we went back and forth earlier this morning, you are court appointed, and we're obviously very grateful to you for taking on this case, even in the face of challenges with respect to payment. I think if our appropriators had been in this courtroom today, they would have realized the bang that they're getting for their buck when it comes to court-appointed work. You did a wonderful job representing your client in this case, and Mr. Garnett, you did the same in representing the interests of the United States. We'll come down and greet you both, move on to our second case. Our second case is 25-1188, City of Southfield, General Employees Retirement versus Advance Auto Parts, Inc. Counsel, whenever you're ready.
May it please the court, I'm Dana Kersvang for the City of Southfield General Employees Retirement System. We are here today just on whether there is enough in this complaint to survive a motion to dismiss. We need a strong inference of scienter, but all that means is that the inference here that they were severely reckless as to the risk of misleading investors is at least as strong as the innocent inference. If it's even the same, we get a chance to prove our case. And the defendants here said things that were not true based on false accounting. Those things were material, and they caused the stock price to plummet. There's no dispute about those things. The district court found materiality, and that's not being appealed. So in addition to that, the CEO and CFO described themselves as laser focused on margins and costs. They got a lot of questions from investors on margins and costs, and they had used these vendor incentives to mask margins in the past, just the year before.
So can I ask you about that statement? It seems logical that CEOs and CFOs would always be focused on margins and costs. But the question, I think, is whether or not they were focused on this subset of margins and costs, these vendor credits and the other category, which I forget at the moment. Why would they have been focused on that?
Sure, Your Honor. For one thing, it's their critical accounting policy, right? They say in their SEC filings, which they all sign, that this is the first of two critical accounting policies. It really matters because they have this whole turnaround story about increasing margins for this company that they say, going into their performance reviews and bonus is going to set them up for a really good 2023. And these are the numbers that tell them if they are doing it right. So we have the critical accounting policy. We have the fact that this is key to their turnaround story. And then we have the fact that they've done it before, that the year before they used these vendor incentives to mask product margins. A confidential witness saved an email from the senior vice president of finance saying that they were, in fact, masking margins with these vendor credits. Then we have the fact that the biggest bump comes in right before that shareholder vote on pay package and bonus calculations. And then I think another thing that is really critical here and sets this case apart from some of the others is that it's not until somebody else steps in to supervise that the facts start to come out about this false accounting. And the remediation includes getting rid of the CAO and CFO. They say that explicitly, and of course they also, the CEO also retires. They
Can I
bring
ask you
somebody in
about this
early.
issue with respect to the confidential informant? Is it
Absolutely,
your
Your Honor.
claim that the informant testified or would have testified that these individual defendants did the same thing?
So the confidential informant would testify that Advance Auto did the same
But
thing.
not these individual defendants.
Right, so the confidential informant's email exchange was with the senior vice president of finance, and that person acknowledged that they were masking the margins. And then the confidential informant believes, but doesn't have a smoking gun conversation, because we don't need a smoking gun, the Supreme Court said in Teleps, but that person believes that everybody up the chain was following this. He talked about management at the top levels being obsessed with these numbers.
Well, that's his personal belief, but what's the evidence that that actually happened?
Right, so we have the fact that Greco and Shepard, right, the CEO and CFO, are repeatedly talking about being laser focused on margins and costs, the critical accounting policy, the timing in terms of this big bump right before their shareholder vote and pay packages, and the fact, and this makes this different from cases like Yates, it was not until after the somebody else stepped in to supervise, right? The chairman of the board steps in, they get rid of this, the first thing comes out, they get rid of the CAO and CFO as part of the remediation, a new CEO steps in, and it's only then that they start to issue restatements.
So
And then-
with respect to the pay packages, you just mentioned that, so I'll ask you about that. So a couple things about that. The shareholder vote was not, I mean, that package had already been approved, right? The shareholders weren't approving a pay package.
So the say and pay vote, I mean, the shareholders get their say on pay, right? So it's not, we don't know what would have happened had they voted it down, but we do know that they had to go before the shareholders and justify their pay based on company performance. And,
Company performance from a different time period that had nothing to do with this period.
oh, no.
Okay.
I'm sorry, that's a big misunderstanding, Your Honor. So the say and pay vote, that is the spring of the 2023. They're looking at the 2022 numbers. That biggest false accounting, it's like a quarter of all of the false accounting happens in that last quarter of 2022. And that lets them tell the story, which you can see in their investor call at JA 256 to 289, lets them go into their say and pay vote telling the story that even though 2022 wasn't that good, their margins really improved in that last quarter because of that false accounting. And because the margins really improved, they say, we're well positioned for a really good 2023, right? So their whole story about their success of their 3-year margin improvement initiative turns on this false accounting. And the biggest false accounting is right before that say and pay vote. Then, right after that, when the first quarter of 2023 numbers come out, those aren't good. The chairman of the board steps in. This starts to unravel. But going into that say and pay vote, they had those numbers. And this court in Boykin, it talked about, maybe if there were performance review, right? Defending your pay based on company performance is way more than a performance review. We also, of course, have the bonus for the CEO. That was a 6-figure additional amount of money that he got because of these this false accounting. Something like 20% of the CEO and CFO bonuses came from the false accounting. So
Just so I understand your theory of the case, it's not, you don't have any evidence that these executives actually knew or were engaged in this false accounting, but they either it's more, I guess your theory is, well, correct me if I'm wrong, that they should have known and were reckless in not knowing if they didn't.
Well, we don't have a conversation
Right.
that they knew, right? So them being reckless is enough. I think there's enough here to think that they did know, but being reckless is enough to get us a chance to prove our case. And here, where they have their critical accounting policy, something they've messed with before, they have this big bump. They called it a critical accounting policy in their SEC filings, which they all signed off on. So, even if they just did that and then nobody checked to make sure they were following it, that would make this a case like Avaya out of the Third Circuit. But we have a lot more than that here in terms of the timing with the pay, in terms of their laser focus on margins. And of course, the inference that they were at least reckless just needs to be equally strong as any kind of innocent inference. And respectfully, the district court really missed some things here, right? The district court didn't talk about any of these things because it thought that the fact that they had disclosed information later shows good faith. And that just makes no sense. It especially makes no sense here because it wasn't the same people who disclosed it later. And in general, it can't be right that it's not fraud if it gets disclosed later, right? The Seventh Circuit in Tell Labs talks about investors don't want to ride a roller coaster. So there are real reasons that a company without these security laws that protect the market would want to hold off on releasing information until the Seventh Circuit said it's like embezzling funds and then trying to win the money back at the racetrack. You want to make things sort of smooth out. If there are no further questions, I'd like to reserve the remainder of my time.
I have one short question.
Yes?
Given the decrease in the share value, one of those officers actually lost way more than he stood to gain. Like, I think it was somewhere in the record about 12 times. How does that fall into your theory or support your theory that those officers actually knew?
Yes, Your Honor. So, first of all, nobody actually lost money on the stock, right? They just didn't make as much money as they would have made, but they didn't pay for that stock. So they're still selling it. It was $50 a share at the end, which is down 2/3, but it's still $50 a share. There's no rule that executives have to dump their stock, this court said in Zach. And there are a lot of both rules and practical reasons that an executive wouldn't do that, would hold on to stock. But I think the key here is that nobody ever falsifies accounting expecting to get caught, right? When you're stealing from the cookie jar, I assume you're hoping that you're going to get money and you're going to be able to put the money back, and it's going to be like the Seventh Circuit said, you're going to keep your investors off the roller coaster and your share price is going to stay high. But here, they ran out of time. The first quarter of 2023 was bad. The chairman of the board steps in to, in his words, provide oversight, and that's when the information starts to come out. So I don't think that anybody thinks that they went into this with the plan of taking the stock.
Can I ask you about the issue of the size of these errors? $100 million in the abstract is a huge amount of money. I think all of us would love to have that.
Yes,
I
Your
wouldn't be here. I'd be on an island in the Caribbean if I had $100 million. But your colleagues on the other side say that it matters what you're comparing that huge amount in the abstract to. They say that it's appropriate to compare it to Advance Auto's total revenues, which apparently were $11 billion in the relevant time period. You say, no, it's operating income. Why do you say that?
Sure, Your Honor. Just to take us, it's operating income because operating income really matters, right? This is one thing they were focused on. This is what their bonuses turned on, and their operating income is $114 million. So when your income that you're using as a business is off by a lot, that's the kind of thing that would show up. It's also, in terms of whether this is a big deal, the district court held that it was material, and it made the stock price plummet. So we really already know that it's a big deal. I think even more than operating income, you should be comparing it to margins. And margins, they're laser focused on those. They're tracking them in basis points, which is 100th of 1%. And when you're looking at something in the 100th of 1%, you are way more likely to notice if it is off by this much. Of course, in addition to the size, the fact that they and the investors are laser focused, we also have the timing, the fact that it doesn't get disclosed until other people come in, the fact that the CAO and CFO leave abruptly as part of what Advance Auto later describes
You
as
just
its
said something that
remediation.
I think may not be entirely true. You said it doesn't get disclosed until new people come in. At least one of the periods of time was disclosed by these defendants, right?
Sort of, Your Honor. So they have that bad first quarter, the chairman of the board steps in, and it's when the chairman of the board steps in that they disclose that first $17 million. But at that point, also the CEO isn't forthcoming. There's this back and forth in the call with investors where somebody says, you're revising your numbers down, you had this bad quarter, you said margins were good, what's going on? Is it something internal, is it something external? He says, oh, this is external. This is about, competition on for our professional products. He's not forthcoming about the accounting issues even then. And they don't say restatement until they have a new CEO. And my friend on the other side makes the point that they don't have the new CFO and CAO then. That's true, but it just underscores how abruptly these people left. They have the new acting team in place by the time they say restatement. And, the amount of time here, it's not until November, right? It's about 6 months after that first $17 million when the CEO was talking about external factors. That amount of time is also really different from those cases where the same people are in charge and they're trying to, work to release information as it comes out.
All right. Thank you. You still have time. You've got 5 minutes left for rebuttal.
Thank you, Your Honor.
Mr. Regan?
Good morning, Honors, and may it please the Court. My name is William Regan with Hogan Lovells, and I will be presenting the majority of the argument on behalf of Advance Auto Parts and its senior executives today. My partner, Ms. Wirtz, will discuss the Reform Act Safe Harbor and the puffery arguments that were raised below but not addressed in Judge Deaver's decision. We very much appreciate the Court's time today and in hearing oral argument. This is a securities fraud class action that plaintiff appellant tries to cobble together from two largely unrelated sets of facts. First, the plaintiff alleges that Advance corrected 3 sets of accounting errors over the course of 2023. 1 through what we call an out-of-period adjustment, and 2 through what are called little r restatements or revisions. Second, plaintiffs allege that Advance Auto issued a financial forecast for 2023 in February of that year, and then reduced the forecast at each quarter end in May, August, and November. In reviewing these allegations, I think it's important to start with the unique statutory and case law framework that governs securities cases. As this Court has repeatedly recognized in cases such as Janies v. Sempra, Boykin v. K-12, Cozzarelli v. Inspire, Teachers Retirement v. Hunter, and Ottman v. Hanger, Congress adopted the Private Securities Litigation Reform Act to limit and curtail abuse of securities class actions. In furtherance of that goal, the Reform Act does a number of things, the most important of which for today's purposes are the heightened pleading standard. To survive a motion to dismiss in a securities class action, the plaintiff must plead particularized facts demonstrating that the defendants made material false statements with the intent to deceive their investors. The intent or scienter element is key. Scienter can be shown by demonstrating either that the defendants had actual knowledge that their statements were false when made, or that the defendants were reckless in the extreme, with recklessness in this context being something close to or tantamount to intentional misconduct. And that was this Court's holding in the CZ v. Duratec. Under the Reform Act, the plaintiff must plead facts giving rise to a strong inference of scienter. In Telabs, the Supreme Court held that an inference of scienter is strong only if it is cogent and at least as compelling as any non-fraudulent inference. So in that case, the Supreme Court established essentially a comparative weighing analysis. This Court must compare the inference of misconduct that plaintiffs proffer against any competing innocent explanations for defendant's conduct and determine if the Reform Act standard is met. This court's securities class action precedents make clear that the plaintiff needs to show fraud through intentionality. Bad accounting or inaccurate forecasting is not sufficient as a matter of law. Negligence or even gross negligence does not suffice. And certainly fraud by hindsight allegations do not meet the Reform Act test. So with that framework in mind, I think it's important to note.
You said bad accounting wouldn't suffice, but I mean, I suppose if it were really egregiously bad, such that it would have been obvious to someone had they bothered to look, that might be enough, no?
Theoretically possible, but there are multiple cases, in this court, we can get to that in just a moment, where there were similar or even worse accounting issues that arose. And absent some evidence of intentionality, this court consistently finds that scienter is not met. Problematic accounting habits, particularly in large, complex businesses like Advance, but you still need some indication that there's intentionality. Maybe it's bad accounting plus stock sales or something along those lines. But bad accounting alone generally is not sufficient to show scienter. You could imagine a situation where a company has one product and the accounting is so egregiously overstated that you could infer from the nature of the accounting errors that the executives here knew that the accounting was bad. So yes, theoretically possible, the accounting errors could be so egregious and so central to the company's business that scienter could be established.
Does it depend on the role of the defendant? I mean, you've got three different people here, the chief executive, the CFO, and then an accounting manager, I think. It would seem that that last person might be someone who might be held to a different standard with respect to accounting errors.
It certainly would be a fair inference that that person was at least one step closer to the issues. You would still need to infer that that person acted with intentional misconduct, not that the person was negligent or grossly negligent, but the fact that they are the chief accounting officer, they're at least one step closer to accounting issues, and it would be fair to put that fact on the scales of the TELAB's weighing analysis.
So your colleague on the other side says that, you know, these folks were, as she puts it, laser focused on margins and costs, and she says that the corollary of that is that necessarily that's connected to this issue of vendor credits and returns because those two go hand in hand. Do you agree with that?
No, I don't think that the plaintiff's allegation here fairly represents what is said and what is not said in the earnings calls that they quote. Analysts constantly ask Advance Auto in the transcripts that are before the court in the record, how are you doing in terms of improving top-line sales, your gross revenue? How are you doing in terms of improving margins and being more profitable? And the laser-focused quote, if you read it in context of the question, the answer is, we are laser-focused on our business. We are trying to grow the top line and at the same time improve our margins as well. So I think it's sort of a generic statement that we are executives and we care about the business and we're trying to grow the top line and the bottom line. I don't think it's anything more than that. So I think touching on where Judge Groh started before.
Oh, you promoted her.
It's inevitable, right? For the accounting allegations, I think it's important to start with what the plaintiff does not allege. There's no document in the complaint showing that anyone knew the accounting was problematic. There's no former employee allegation saying that anyone at Advance knew any of its financial statements were inaccurate at the time the financial statements were issued.
Although there is this anonymous employee that suggests that in some other context, folks may have had knowledge. I mean, what are we supposed to do with that?
Yeah, I don't think the court should credit that person at all. The person did not work at the company during the class period, so the person cannot speak to anything that was true or not true during the class period. The complaint also does not provide the required indicia of reliability. The person's name is not given, their title is not given. They work in the financial planning and analysis group and not the accounting group. There's no indication of who the person reports to. And there's no indication that the person ever spoke with any senior executive at the company. So these are very vague and ambiguous allegations with no detail provided, and therefore they don't meet the particularity requirements of the Reform Act. So no former employee allegations, and I think that's particularly striking here because if it was true, as plaintiffs allege, that a public company was intentionally misstating its financial statements for nearly 3 years, somebody would have said something somewhere along the way. The fact that they have no former employees attacking the accounting is, I think, a telling absence. Also missing from the complaint is any allegation, as you see in some other cases that the court has decided, of an SEC enforcement action challenging the company's accounting or an auditor resignation. There are none of those other potential indicia of fraud here in this case at all. Same with respect to the forecast allegations. No documents, no former employees, no anything suggesting that anyone at Advance knew its forecast was not achievable on the day it was issued. This is all fraud by hindsight.
So the employees were, I mean, they were let go. I mean, what do we make of that?
Companies have turnover, particularly when the business is not performing well, and that's really what happened here. I think the plaintiffs would ask the court to assume that people left because of some fraud or misconduct, and I don't think the chronology supports that. The first indication of accounting problems was at the end of Q1 2023 in May. And there, Advance discloses a $17 million accounting problem that it fixes through an out-of-period adjustment. At the same time, with the CEO, the CFO, and the CAO, the three individual defendants still employed by the company, Advance discloses a material weakness in its internal controls over financial reporting. It says basically we don't have enough accounting personnel on hand, and that's causing us problems. So the defendants just voluntarily disclose that to the market. The defendants voluntarily disclose the first accounting correction. At the same time, they also lower the forecast. So the notion that some new management came in and saved the day and discovered the fraud just doesn't hold up when you read the chronology of when the accounting errors were noticed, when the forecast was lowered, and when the internal weakness was reported to the market.
Well, your colleague on the other side says that that first disclosure wasn't complete in the sense that the reason given masked the real reason. She says it was that they asserted that it was an issue of competitiveness in the broader market, when in fact it was these accounting snafus that caused the problem.
I think Your Honor is referencing the external factors argument that they advance in the complaint. I think that suffers from a threshold problem that it's really a Frankenstein quote. That's not what the company said. If you look at the quote in the complaint and then open up the earnings call transcript that it's taken from, the excerpts come from page 5, page 7, and page 23, and they're Frankenstein together to make it look like.
I was about to ask you what you meant by that, but now you've explained it.
Yeah, it was a selective editing exercise in the complaint to make it look like the analyst said, hey, what was the cause of you lowering the forecast? And the answer was external factors. And certainly external factors were cited, but a whole host of factors over the course of 30 pages were cited. So I don't think the quote fairly represents what was said. And even if the executive did point to external factors, there's nothing in the complaint that says that wasn't a contributory factor. The company announced that it was experiencing more competition in the professional segment than it had previously experienced before, and that was causing it to adjust prices downward and therefore try to grow the top line but hurt margins at the same time. So I don't think the external factors.
Mr. Regan, do you admit that they did anything wrong?
They did not account for the business well, I think, and the forecast was not great. It was off by a significant margin, but there's no fraud here. There's no intentionality here at all.
Well, I mean, certainly they would know that if you subtract the vendor credits from the cost of goods and keep your net sales the same, you're going to inflate, right, margins, right?
Yeah, so on the vendor incentives versus vendor credits, I think the complaint assumes too much, is probably the way to think about it. When Advance announced the second and third sets of accounting issues, that's the only time it said what the cause was. And it said that the issues were related to product returns and vendor credits. Product returns is if Advance needs to return an item to a vendor for any reason. It doesn't work, the customer didn't want it, they're not selling. Advance returns the product to the vendor, and the vendor owes Advance some form of credit. Vendor incentives are something very different, and Advance never attributed any of the accounting issues to vendor incentives. Vendor incentives are essentially coupons or discounts that a vendor might offer Advance, or promotional allowances for that matter. But coupons or discounts that Advance might be offered by a vendor in order to promote the product.
Did they subtract those?
Eventually, but
right? Didn't they subtract those as well from cost of goods sold?
they are required to, but the accounting is far more complicated than that. If you look at the critical accounting policy that is quoted in the complaint, it is an incredibly complex process as how to deal with vendor incentives. There are, I think, more than 1,400 vendors that the company has, and sell that through those vendors, the company buys more than 23,000 products. And the accounting question turned on things like, is the vendor offering something that is specifically attributable to one particular product? Is it quantifiable? And when is it going to come to pass? Is it going to come to pass this year or next year? And if you go down one path, you end up immediately subtracting, the way Your Honor was calculating, from selling general and administrative expenses, SG&A.
Right.
If it's not quite that identifiable, if it's not going to happen this year, or you can't quantify it, it kind of gets even more complicated. Then you have to sort of treat it as deferred revenue. It gets recorded initially as a reduction to inventory, and then the following year when the product gets sold, it gets treated as a reduction to cost of sales. So it's a wildly complex process. I think the more important point here is that Advance never attributed anything to vendor incentives, and nothing in the complaint goes through the analysis of the vendor incentives policy and says Advance did or did not follow it. The only word they care about in that section of the complaint is the fact that we use the word critical. And so they say, therefore, it was important. But they never actually analyzed the policy or provided any particularities around whether Advance did or did not comply with that policy. And so we talked a little bit about what was not there for both the accounting allegations and for the forecast allegation. For both sets of allegations, it's important to note that there's no financial motive. No one sold stock during the 12-month law class period. Not the individual defendants, not the rest of the board, not any other employees at Advance. No one sold stock while the senior executives were allegedly out there fraudulently inflating the stock price. That is a very compelling fact. During the class period, no one at Advance, or Advance never used what was supposedly an allegedly inflated stock price to go out and make acquisitions. They didn't use it as currency. And Advance did not go out to the market and raise capital from investors while allegedly overstating its financial prospects and the state of the business. And this court has held that while viable motive allegations are not 100% required, the absence of them weighs heavily against plaintiffs in the Sienter analysis. The court found that in the San Antonio fire case versus Syneos Health and an In Re Triangle Capital Court. So the issue for the court really is, in light of any actual knowledge allegations, and in light of the absence of any motive allegations, financial motive allegations, do the plaintiff's other circumstantial allegations of misconduct give rise to the strong inference of fraud required by the Reform Act? They do not. The district court referred to the plaintiff's approach in this case as
So
shotgun.
Regan, I hate to interrupt you, but you're over your time. I'll let you wrap up really quickly.
No, I think unless the court has any questions, I will turn it over to my colleague and let her address the Reform Act, safe harbor, and the puffery arguments. But again, if the court has any questions, I'm more than happy to answer them.
Thank you.
Thank you.
Good morning, and may it please the court. My name is Allison Wirtz, and as Mr. Regan indicated, I will briefly address the three additional grounds for affirmance. First, that the company's guidance for 2023 and related statements are protected by the Reform Act's safe harbor for forward-looking statements. Second, that the amended complaint fails to allege facts showing that many of the purported false statements were actually false. And third, that some of the challenged statements are immaterial puffery. With respect to the forward-looking statements, the Reform Act provides that statements that are forward-looking and accompanied by meaningful cautionary language are inactionable to support.
Can I ask you, sorry to interrupt your
That's fine.
train of thought there, but if we were to agree with the plaintiffs that they've made out a sufficient claim of Sienter, why would we take on these issues instead of just sending it back down to the district court?
The panel certainly I think it's meaningful that we have two sets of allegations, let me put it that way. So we have the forecast allegations that relate to the 2023 forecast, looking forward, and the lowering of that forecast over time. And then we have the accounting allegations, right, the backward-looking allegations that over the course of 11 quarters, there were accounting issues that were raised. While plaintiffs tried to kind of meld those two together, they really are distinct in the sense that there was a set of statements made about the accounting, there are a set of statements made about the forecast. So it would meaningfully change the case and the scope of discovery and the scope of the issues that are present if the case were to go through fully with respect to both the forecast allegations and the accounting allegations, or if the case were cabined to just the accounting allegations. So the argument here would be that if the panel was inclined to agree with plaintiffs that there is scienter with respect to the accounting allegations or the forecast allegations, if they can't plead falsity, which is what these arguments go to, then the forecast allegations can be dismissed and the case can be substantially narrowed.
Okay.
So financial projections are quintessential forward-looking statements. They're right there in the definition in the Private Securities Litigation Reform Act. So the 2023 guidance and the subsequent updates in May, August, and November are all forward-looking statements. And in addition, a lot of the statements that were made in connection with the forecast and the updating are also forward-looking. For example, in paragraph 94 of the complaint, there's discussion about what AAP is planning to do going forward in 2023, for example. It's forward-looking. Paragraph 95 also mentions what Advance Auto is planning to do from here, meaning in the future. So these statements are forward-looking, and if they're accompanied by cautionary language, which they are here, they are inactionable to support a claim. And here there was sufficient cautionary language. Both the press release and the investor call, where those statements appear, contain warnings about forward-looking statements and reference Advance's Form 10K that contains a host of risk factors, many of which are specific to the issues here. For example, there's a risk factor that says that if Advance is unable to implement its strategic initiatives effectively and efficiently, the financial condition would be affected, which is exactly what plaintiffs are saying happened here. So those statements are inactionable for those reasons. In addition, with respect to allegations of falsity, for a number of these statements, the complaint actually doesn't allege particularized facts showing that those statements were false, and Mr. Regan touched on this a little bit. But there's an allegation in paragraphs 94 and 95 that Advance Auto spoke about the majority of the integration of its business, about engaging in significant investments in complex transformation initiatives. And the complaint is entirely devoid of allegations that those things didn't actually happen. And if there are no allegations showing that those statements were false, they certainly cannot be the basis for a fraud claim. Finally, with respect to puffery, it's well established that immaterial corporate optimism or puffing statements are inactionable. And here we have a couple of statements related to elevating our performance, for example, or we're confident that we can continue to grow margins from here. These are the types of generic corporate statements that any CEO or CFO would say to the market that an investor would not view as material when making an investment decision. And for that reason, those statements are inactionable as well. If the panel doesn't have any other questions, we'll leave it at that.
All right. Thank you very much.
Thank you very much.
Thank you, Your Honors. I think I have about 5 things that I want to say in response. First, I'd like to just address these supposed Frankenstein quotes. So the laser focus point, it's cited in a number of places, comes up a lot, so you can see a few sites in our brief, but I'll just point you to JA 270, where they're on an investor call. One of the investors says, on this margin guidance, can you tell us about gross margin versus SG&A, which is sort of general expenses? And Jeff Shepard, the CFO, says, we're laser focused on both growing our gross margin while controlling our cost base, right? So he's saying the focus is, in fact, on the margins. In terms of external factors, I would point you to JA 313, where this is the investor call of May 31, right, when the chairman of the board steps in to exercise oversight, and Shepard is still, the CEO, Greco, is still saying that external factors. So one of the investors says, so you're well into this transformation with margins, and it seems like you're taking a step back on margins and free cash flow. We had a conversation earlier about why cash is an important thing to look at. and you've cut your guidance, is this internally catalyzed or externally catalyzed? And the CEO says, I think it's external. I mean, the dynamic has changed on the pro side, right? So he does not say anything about accounting problems there. In terms of whether there's anything showing that whether these dismissals show misconduct, this is a case where the CAO and CFO Advance said in its restatement that it let them go as part of its remediation. You can see that at JA 69. In terms of vendor incentives, what they said today about how this accounting worked, it isn't in the record. We're here on a motion to dismiss. On our allegation is that this was about vendor incentives. And that makes a lot of sense because the way these incentives worked, you can see it at JA 53, 54, they got rebates based on the amount they sell. They get those in the form of vendor credits. So when they're in the restatement, they say vendor credits. Their rebates are in the form of vendor credits. The rebates are tiered. So, for example, if you sold between 200 and 300, you might get a $10 rebate on everything, whereas if you only sold between 100 and 200, you might get a $7 rebate. I'm making those numbers up, but you get the point that the number of returns can change which tier you're in, which is why vendor returns.
And what of these are violations of GAAP?
These are violations of GAAP. I'm sorry.
They are violations. They can't use incentives.
No. I'm sorry, Your Honor. They can absolutely use incentives.
Absolutely. Right. But what are the GAAP violations?
Yeah, the GAAP violation and their policy, which was consistent with GAAP, is that they're supposed to estimate what those incentives are going to be, what their actual costs are going to be, and then they're supposed to be updating that. And what they say they're doing, but apparently we're not doing, is going back and making sure that their estimates are right. Now, this might seem technical, but it was their critical accounting policy, right? It was the first of one they told SEC.
That's kind of difficult, though, if your point is correct, assuming that it is, to get that to the point of the high level of scienter required, because that's a little high. It's close to fraud, if not fraud, almost in terms of pleading. I'm talking about the pleading standard, right?
Yes, Your Honor, it is fraud. And if you're estimating something and you're doing it in good faith, sometimes you're going to be high, sometimes you're going to be low. That's not what happened here. They were always wrong in the way that helped them to the tune of $100 million.
Being wrong may not be enough, though, for the pleading standard.
Yes, Your Honor, and I didn't mean to say that I think they are only wrong. I'm just saying that if you're estimating in good faith, you're going to be off in both directions. The fact that they've monkeyed with these numbers before, and then they come in with $100 million that all go the same direction, all go to pump up margins, really tells you that this, at least we should get a chance to prove our case here.
Well, that's, I know, well,
No, go ahead. Yeah,
that's one of the problems, though, that the reason why the law is as it is, it's not just enough to say, I get enough to go in there. It's a lot of companies would spend a whole lot of money on these cases like this. If people could do it sort of, well, I think it's wrong, you did it right, or it's the better way to do it, wasn't best practices, those kind of things, like we don't want to do that. I'm not saying but that's what's, as a court, we look at it in terms of what the purpose was, right? And that's what the district court is looking at, whether or not you really have done enough in terms of pleading to be able to go in and make companies have to spend a lot of money on attorney's fees and all kind of things like that to either win or lose. But go ahead.
Thank you, Your Honor. I know I'm out of time, so I'll make it.
The chief is allowing me to do it.
Great.
Go ahead.
So there are accounting questions that are tough, right, where people make mistakes. This isn't one. This was their critical accounting policy, that in that same 10K filing, that they all sign right before their pay packages and their bonuses are calculated. They say, this is our critical accounting policy. We are reviewing these estimates. We are making sure they're correct. You can see that at JA 53, 54. So this isn't in that category. This is something that they said was critical, that they're really focused on because it's important to their story, that they have monkeyed around with to hide margins before. I didn't get to the confidential witness, but if you just go back and look at JA 31, 32, you can see that this is somebody who really knew what they were talking about. Their job responsibilities are monitoring margins, and they are in the part of the company that supports those vendor credit and vendor rebate process. So when you look at all of that together, as you need to do, I think we should at least get a chance to prove our case here. If there are no further questions, I ask that the court reverse.
Thank you very much. I want to thank all three counsel for their fine arguments this morning. We'll come down and greet you and adjourn for the day.